Can I just say something about Andrea?
Welcome back, everybody. It is time for part 3 of the Robert Devine decertification hearing. This one is going to be a little bit shorter. Apparently, they had a short day for the hearing on this one. If you remember from the end of part 2, they were discussing some scheduling issues concerning Brian Holmes, who is the internal affairs investigator. He has a training today, so he isn't able to come back. They're going to take some defense witnesses out of order, but it doesn't sound like the commission plans to call any other witnesses. So what I'm kind of anticipating is that we're going to get through those defense witnesses, and then there won't be any more. There won't be Mr. Holmes. The defense is not going to want to proceed any further with their case. They've made it clear they don't want to put Mr. Devine on the stand, so to speak, metaphorically speaking, until after the commission has completely rested their case. So my suspicion is that that's what's triggered the short day today. But of course, we will have to see how it unfolds. So far, what we have learned over the course of the last couple hearings is that the reason why they're seeking decertification is allegations of repeated, sustained findings of misconduct, conduct unbecoming, instances of dishonesty. So there was an instance from 2015 that Mr. Devine, Officer Devine, is apparently not contesting, but he is taking issue with the 2021 IA investigation that concerns alleged misconduct towards Sandra BIRCHMORE. His defense about that is he didn't do it. He didn't do it. Wasn't me that did it. And so we're starting to see kind of the bones of the case, that he is the person who had communications with Sandra BIRCHMORE under this pseudonym Marty Riggs. And this communications apparently are fairly damning, because although we don't get to see them and we don't get to hear a lot of the basis for the conclusion that he was Marty Riggs, we do see the defense fighting very, very hard procedurally to try to block a lot of this evidence. And in at least one respect, the judge seems to be picking up what they're laying down. Certain of the witnesses that were investigated during the investigative affairs proceeding, according to Mr. Holmes, their interviews were recorded and transcripts were prepared. The defense says, I was never provided any of that. The commission says, I don't have any of it to give them. So there's kind of a dispute about whatever happened to these original recordings and the interview transcripts. And the judge is concerned about that. It's made it clear he wants these transcripts hunted down, or if not, then the commission is going to need to consider calling the officers who conducted some of these interviews. The other, I guess, allegation, the defense to the accusation that he was involved in these communications with Sandra BIRCHMORE is that I was hacked. And it seems this is also unclear. Haven't quite gotten a real picture of this, but the implication seems to be he's claiming like this massive hack of Facebook, WhatsApp, Snapchat. I can't even remember like all of the different communication sources that he's claiming internet issues were the source of those communications, and not in fact him. So we're just kind of waiting to see how much more of this information we're going to be able to get into. So with that, guys, let's go ahead and turn to this next day of the hearing.
Is the mic on? Okay. Sorry. I'll just start over. Good morning, everyone. Today is Friday, June 6, 2025. The time is 10:37 a.m. and this proceeding is hereby called to order. This is the second day of the adjudicatory hearing before the Massachusetts Peace Officer Standards and Training Commission in the matter of Robert Devine. This hearing is closed to the public pursuant to an order issued by the hearing officer on May 30th, 2025. Reconvening in person and only necessary commission staff are permitted to observe the hearing. This hearing is being audio and video recorded, and the party should speak directly into the microphone to ensure the audio in the recording is clear. The commission is represented by Attorney Sean Martinez, and the respondent is represented by Attorney Robert Stowe. My name is Elizabeth Smith, and I'm the hearings administrator for the commission. The Honorable Kenneth J. Fishman will serve as the hearing officer for this proceeding. And before we begin, the parties are reminded to use initials when referring to any alleged victims or minors, and to use a page's specific Bates number when referring to any exhibit. And this matter is now before Judge Fishman.
Thank you. And for the record, counsel, state their appearances, please.
Good morning, Sean Martinez for the Division of Police Standards.
Robert Sullivan responded. Robert Devine.
Good morning.
Morning.
So before we begin with evidence today, and Mr. Stowe mentioned on the way in that one of his two witnesses is on the way, delayed some, and the other one I'm not sure about.
Correct. I understand from my client that he's had some in the past of problems with some heart issues, with stint and things like that. So
He's had some what?
heart problems. He had a stint put in.
Oh,
And we don't. He hasn't reached out to me. My subpoenas have my phone number on the bottom of them. So
which one is that? Which person is that?
Haley Hogan is on her way.
All right. Well, let's see what happens with that. I do want to start before evidence anyway, just to put on the record that a Boston Globe article was directed to my attention yesterday. And in that article by Laura Grimaldi, she indicated that she had interviewed Mr. Devine, who told her, quote, "I asked for this hearing, I wanted it public, and it's not." So I raised this simply because I want to make sure that the record reflects, as far as I can recall, that neither Mr. Devine or his counsel, Mr. Stowe, throughout these proceedings has ever requested that this hearing be open to the public or objected to the orders to close it. Rather, two protective orders were submitted to me for my approval, which were prepared by the parties and agreed to by the parties, both requesting confidentiality. And beyond that, as we were approaching the hearing, I instructed counsel to confer, which they did, which reported to me that they did, and discuss whether, I asked you to discuss whether confidential matters could be segregated from non-confidential matters at the hearing so that the public could be present at the hearing during the presentation of non-confidential material.
No
I
way.
was told that both parties agreed, that they advised me that so many words that they didn't think that would be feasible because of the nature of the evidence. So I'm asking you, first of all, does that accurately reflect the record as far as the party's concerned? I'll start with Mr. Stowe.
Mr. Stowe, is your client a lying liar who lies? That's quite convenient and self-serving, isn't it? Going to court, proposing confidentiality orders, but then going to the press and saying, I wanted all this to be open. Well, your actions didn't show that you wanted it all to be open. Now, we've already seen that, this hearing has now been opened, at least to the extent that we get to watch the hearing, but there is a lot of it that we haven't been able to see, and we don't know exactly why. I have suspicions about it. My suspicion about it is that similar to like what we saw in Karen Reed, there are materials obtained from the federal investigation that are being used in this proceeding. And like we saw in Karen Reed, there are some confidentiality conditions attached to the production and use of those materials. Again, this is just a guess, but there was a reference by Mr. Martinez in yesterday's hearing about kind of the difference between being able to get materials from the Stoughton County Police versus getting them from a federal agency. So that does imply that they have some experience with the difficulties that there can be in getting federal materials. So that's my guess as for the reason for at least some confidentiality here. But nevertheless, to be going and running to the press with this story that's kind of contradicted by your own legal advocates actions taken on your behalf in this proceeding to keep them non-public? Yeah, hearing officers noticed. Counsel, would you like to explain why your client is a lying liar who lies? What do you have to say about that?
Yes, Your Honor.
Mr. Martinez?
Yes, Your Honor.
And
So
have
that's
the
accurate.
parties either changed their view about the need for confidentiality in this case?
I believe my client would like it to be an open forum, but that's his position, and
Well, it's hard for me to know it unless you.
unless I say it, yes, no, he's expressed to me that he would wishes it would be open.
Well, I don't want to get into, okay, that's fine that you're telling me that, but I'm just hearing this for the first time now.
I understand.
Is this something that you at any time felt you didn't have the opportunity to present to me in the past?
No, I just, it was not presented in the past, and also throughout this hearings, as you know, and any meetings we've had, Mr. Devine's been with me.
On behalf of Mr. Devine, do you believe that there are any circumstances that have changed since the parties presented protective orders to me and discussed the possibility of segregating the material here that would sort of alleviate the need for confidentiality?
I don't think so, Your Honor. My position as counsel, as I've instructed my client, is that this should be confidential. So this is, I've had this discussion,
Okay.
and it's my position as counsel that this should be a private, a closed hearing.
And Mr. Martinez, has your view changed at all on this?
It has not, Your Honor.
Okay. I don't really care what the media says, so I'm not asking it for them. What I do care about is transparency. I do care about the public's right to know the point, particularly the nature of the kind of proceedings that we're involved with in the post-commission as a general matter. I was persuaded that this is one of those rare occasions where closure and the presence of protective orders were necessary because of the sensitivity of the nature of the evidence that was being presented, particularly even having in mind that it appears that the media has been pretty well informed, for instance, about the nature of the alleged victim, about much of the evidence that's there. I don't know how much they've actually seen, but I've certainly seen a variety of articles out there that seems to discuss some of the details that I've been hearing about through the discovery process and through the evidence as it's been presented at this hearing. So I did struggle for a while with the notion of, if it's already out there, what are we protecting in terms of confidentiality? And I don't have any doubt that you've thought about that too. But there's also, there were other factors like the presence of a criminal case in which there was a protective order for probably much of the very same material we're dealing with here. And
It's the federal investigative materials. I mean, they're telling us as clearly as they can, a criminal case, that's Matthew Farwell, his prosecution that's pending, that's a federal prosecution. That's what the situation is.
as far as I know, I haven't heard differently. That's still in place in connection with the criminal case. On the other hand, we have the estate of SB that's involved in what appears to be, I wouldn't say open, but it's certainly a civil case that's on the docket in the Superior Court, which identifies SB's full name. But there is a protective order in that civil case as well, isn't there?
There is, and there was a hearing on it. The question was whether or not the town of Stoughton had to disclose information. And there was a full hearing on it, weighing the balance of the sensitivity of the information with the public's need to know. And that was in the civil case, that was in the post case.
Right.
So
So we sort of all came to the same conclusion.
correct.
Yeah.
Judge concluded the same as you did.
Okay.
So we all did, which is, it makes sense for the integrity of both that case and this case.
Yeah, it surprised me, because as I consider the factors, that the estate, at least now, is taking somewhat of a contrary position. Oddly enough, they asked to appear in this proceeding.
Oh, the estate asked to appear in the post-commission proceeding. That's interesting. That's interesting. They have something to say. They have some thoughts, either about the facts or about whether he should be decertified. Interesting.
They didn't say open it up to everybody. They wanted to be present. I don't know what their position would be about generally open to the public hearing or not. But given the nature, particularly of what I was focused on yesterday as a result of presentation of evidence, beyond the identity of SB, there's her communications. And it's to somebody who's from somebody involved with somebody who's no longer alive. And it's the nature of those communications and the the impact it could have on her reputation and other aspects of her life, that the estate would be open to or agree with the opening of of these proceedings. At the during the civil case, when there was a hearing on Mr. Stowe, did the estate take a contrary position? Did they want it open? Remember?
As far as the disclosure of the evidence, I don't recall. I know there was I think we had 2 hearings on it. Because we had the Attorney General's office information as well that they were trying to secure. And this was actually the town of Stoughton. I don't know if it's the town of Stoughton that filed for the protective order. I believe it was.
But you don't recall what position the estate took?
I don't.
All right. Is there anything else so that our record can be as complete as possible that anybody wants to add at this point?
Just as far as the civil case, the estate is now requesting that the civil case be stayed in Norfolk Superior Court. So
Because of the criminal case? Or
I haven't seen the motion. I asked to be served 9A of the motion. My concern was not well if the case gets stayed. What about the interest? The interest should be stayed, and I think that's going to be my limited objection to staying it. Is the interest should be stayed as well.
Yeah, but you don't know the grounds for the stay at this
I
point.
haven't seen the motion.
Mr. Martinez, you want to add anything?
No, Your Honor, I don't.
I'm not sure what he's talking about here as far as the stay. He's talking about the state, but the state isn't a party to the civil suit. There are, institutional defendants as part of the civil suit. But I don't think that. I don't think the state is part of that. The state is not the federal prosecutor either. It's confusing because it's implying that there's some kind of local prosecution that's happening here, but I'm not aware of anything like that. So I don't know if he's talking about the civil case, which has been stayed while the criminal case is ongoing. Maybe this hearing is taking place before that ruling was entered, but just a little bit confusing. There's no stay in the criminal case. It's just dragging, and it's dragging in this kind of confusing way where the guy hasn't even entered a plea in over a year. There's been a superseding indictment, and the case is now set for arraignment, but it's just quite a long period of time to pass in a criminal case without any sort of action moving forward at all. So just a little confusing what is going on with the stay conversation here.
So you're comfortable with continuing to proceed in the manner in which we began these hearings?
I am. I would certainly hesitate, in particular at this point, to open up the hearing if the division's witnesses were behind a closed hearing, and then to have Mr. Devine testify in public. I think that would be an issue.
I actually thought about that as well as I was considering these developments. So, and we can't turn the clock back. So that's, I haven't figured out how to do that yet.
The one, just given it in particular, Mr. Devine's Mr. Stowe's representation that Mr. Devine had never before made his wish known about being public, I would ask permission to cross-examine him on the statement he made to the Globe.
That's right, because he's a lying liar who lies. And one of the grounds for him being decertified is being a lying liar who lies. And his credibility, should he testify in this hearing, is going to be an issue. And so him being a lying liar who lies, it's going to be relevant to that issue. So here we have an instance. Taking inconsistent positions in court and with the press. You going to allow that, Judge?
as well.
I mean, when Mr. Devine takes the stand.
Yes,
All right, well, let me deal with that when it comes.
yes.
All right, but thanks for forewarning me and Mr. Stowe as well. All right, is there anything else you want to talk about while we're waiting for the witness?
So I do have information because the bar status of Robert Kuhn was an issue yesterday. I do have a similar proposed exhibit, or ask that the clerk make a judicial notice of Robert Kuhn's bar status. May I approach?
Yes.
You're right, if I mean, we didn't say bar status, we said he was in law school.
I'll let you talk about it. Let me see what we're talking about. You know what, this is, we have a, let me ask if we can make one for identification mark, B for identification.
Yes.
Now the defense is jumping in. We didn't say bar status. We said law school. But as I recall the testimony from yesterday, and let me just go ahead and maybe see if I can find it in my notes. The issue was that there were some text messages that they attributed to Mr. Devine because he was the only Rob who was in law school at the time and who had passed the bar. So we don't know, of course, what the exact conversations were. We're not getting to hear any of that. But it's one of the defense positions that it wasn't him. Those text messages were with this other officer he's trying to throw under the bus. Officer Kuhn, who apparently also went to law school, but it sounds like there might be some question about the timing. So yeah, let's see. Yeah, I don't have anything real specific about it that I can find real quick. Of course, we're buried in notes about how Celebrate works and trying to educate the court about that. There was nobody else in law school or who had passed the bar. There it is. They believed that. So the context of this was the hacking, the claim that his account was hacked, and was that ever a concern to Brian Holmes? He said no, it was never a concern because he believed that Robert Devine was the Smarty Riggs based on both the Celebrate data and the context of the conversation. And the context of that conversation was that nobody else in the Stoughton Police Department at that time had been in law school or passed the bar. So perhaps there is some conversation vis-a-vis passing the bar that would allow us to establish a time frame, and that's why the Mr. Martinez, the attorney for the post division, I guess, wants to have his bar status entered in so they can have the timeline to show your finger pointing at Mr. Kuhn doesn't work because he hadn't passed the bar at the time of these messages. That's how it makes sense to me. That's why he would want to do it. So is the judge going to take judicial notice of it? I don't know. It's a fact you can look up in a public record. Maybe.
Thank you. And does this come from the bar website?
Yes, it does. I took a screenshot this morning when I searched for Robert Kuhn. I also double checked the commission's databases, and the middle name of the Stoughton police officer is the same as the admitted attorney.
Robert Jerome Kuhn.
Yes.
Robert Jerome.
All right. So What's your position about this document?
Your Honor, we had said that the question before the witness was about Robert Kuhn's being in law school. I can believe his testimony was nobody graduated the name of Robert, nobody's in law school. He brought up the word law school. That's when he brought up the name of Robert Kuhn's, and he says, no, he wasn't. Or word to that effect. And he said, well, yeah, he was. I think he said, well, maybe he was. And so it wasn't a representation that he graduated, it was a representation that law school.
Yeah, just looked at it. There was a comment there about him passing the bar, not having passed the bar.
And if you look at this, he was sworn in. It was admitted on November 15, 2022. I suspect that he was in law school in 2021.
Yeah, unless he took time off between law school and admission, but who knows? I don't know. We really need to go down that. What do you say about that? I know the question originally was about law school. My memory is it got a little blurred by his answer.
Well, he's going to come back to the stand, so they'll have an opportunity to clarify that, won't they? Won't they? If there's something in the message about passing the bar, because this guy, Robert Kuhn, didn't pass the bar until after Sandra BIRCHMORE had already been killed. So if there's messages about I passed the bar or something like that, timing isn't going to work.
But I think that Mr. Holmes, not be completely responsive to your question, what Mr. Stowe was that he did say that another officer, this fellow Robert Kuhn, had become a lawyer around that time, so which implies potentially that it's a member of the bar. Again, I know you were focused on the question of whether anybody in law school. I do recall your question, but so what do you say about that?
My recollection of the testimony is the same as yours, Your Honor. And also just the fact that the evidence in the case, the statement that we're all circling around is the text messages on the admission date of Robert Devine. The fact that
Timing, admission date of Robert Devine versus the admission date of this other Robert, even though we're not going to get to see these text messages because apparently above and beyond the federal materials concern, there's also this concern about her privacy of her messages, which, you know, I sort of understand, but, you know, you could at least show us his. That doesn't deprive her of her privacy. But yeah, if the text message is about his date of admission, it's not going to line up. This is way after Sandra BIRCHMORE was dead and anybody was texting with her.
there's talk of another Robert at the Stoughton Police Department, either being in law school or potentially being an attorney at the time, is now relevant to this hearing. And this shows that he has a different admission date than Mr. Devine.
If I may, Judge, the actual quote is not. I think the actual quote is.
The text messages and then the immediate next text messages.
I just want to be clear.
But do you disagree with that?
No, I agree with that.
Okay. All right. So I think what we're talking about really goes to the weight of the evidence at this point. I think it doesn't change its admissibility. And certainly something I'll have to put in context when I decide if its value in terms of deciding this case. So I'm going to admit what we marked as Exhibit B as the next numbered exhibit.
If I may, I'd just like to point out the fact that I've raised over and over again.
The what?
I'd just like to point out the fact I've raised over and over again that Mr. Devine cannot cross-examine SB because she's not here. So we've got that ongoing problem with that. You know, his due process rights. And of course, we've challenged and we're going to continue to challenge the authenticity.
And so the record is clear. I certainly understand that. And as far as I'm concerned, your rights are preserved. You know, otherwise, with regard to virtually every single question that involves a communication involving SB, you'd have to make this objection again. But you have a continuing objection.
Thank you.
He doesn't want them to be able to use her messages because they can't cross-examine her, which is kind of a common problem when somebody's been murdered. They can't be cross-examined about the things they said. And by the same token, they can't defend their credibility. So that's why what I suspect, based on the groundwork that they've already laid, suggesting, you know, she's lied about various relationships and so forth, they're going to use her death as both a sword and a shield. It is a shield. We can't cross-examine her. This proceeding is unfair. It's a sword. She's not credible anyway, and she's not here to defend herself. So just kind of taking note. That seems to be how they're handling the challenge posed by her communications.
Numbers a little better
So you said it was B. I don't know if you wanted to do numbers or letters because we have been doing numbers.
for ID. I'm talking about
Okay.
versus A and B or ID.
Apologies. Yeah, that would be exhibit 11.
I think we're at exhibit 11.
That's what she just
Okay.
said.
Thank you.
It's great when we all agree.
Don't bite me.
Let's talk a little bit about schedule since we don't have the witness yet.
I'm sorry. This is.
Our schedules.
Witness is here. No,
Yes,
let's get.
but if you'd like to.
No, we can do that later. I was just sort of filling the blank.
Sorry.
Your Honor, if I may inquire, when you left yesterday, you, I believe instructed the division to find out about the, transcript.
Yes, you were gonna try to communicate with the chief. Were you able to do that?
Yes, I was.
Anything
So-
we should know?
Chief McNamara, I spoke with her just this morning at approximately 10:15. She was able to locate all the written transcripts, and she's in the process of locating the audio transcripts, as well as Mr. Devine.
Audio recording.
The audio recording, yes, of the interviews, as well as she's working to locate the Weingarten and Garrity and interview warnings for Mr. Devine. She read the first page of the transcript to me, and there is definitely an acknowledgement of.
When Mr. Devine was
That's
interviewed.
correct. Yeah.
So there's a transcript of his interview as well?
That's correct.
Your Honor, given
Never
the,
seen that?
I've never seen it in any form. And I hesitate to have my client take the stand without him first being able to give him the opportunity to review a transcript of his statement to the police department.
It's not unfair. It really isn't. They didn't, of course, provide any explanation for why Officer Holmes has said, I gave it to Post. Post says, I never got it. And in the meantime, it's apparently still back there at the Stoughton Police Department. Especially if they're going to rely on it. If they're relying on his statements, then yeah, they have a duty to produce to the defense what they're using in support of their allegation. The issue, though, is what is the remedy for that? And normally the remedy for that is have yourself a little continuance. Take some time. Take the time that you need to be able to go and read through these transcripts so that you can be meaningfully prepared to defend yourself against whatever issues might come up as a result of them. And it sounds like they've got some scheduling issues anyway. So I kind of anticipate that's probably where they would go. But let's see.
It's never been produced.
I don't blame you. Why? So we heard from Chief Holmes yesterday that from his perspective, all of that had been turned over to you folks.
Yes.
And I think you said, and I credit that you've checked and double checked.
Yes, I also went back to my office yesterday and checked, and the assigned investigator also checked. And
None of this material is correct. I mean, these transcripts or the audio recordings or the notices that pursuant to the IA procedure, none of that.
that's correct. The hard drive that has been the primary discovery device in this case is what we received from the Stoughton Police Department, and I made an exact copy and turned it over to respondent. That was the representation of the case file. I had turned over the IA report and the exhibits, which are Exhibit 1. We had received those separately from the electronic exhibits. That's why they're separate as Exhibit 1 and Exhibit 2. And I've returned them, or I've turned them over to the respondent in the same form that we received them.
And you both had a chance to obviously thoroughly review those two bodies of evidence. So, and you both concur that the material we're talking about, the transcripts and recordings themselves, are not contained in there, nor are the warnings that we were talking about yesterday.
Yes.
Yes.
So it is kind of important, I think, that this isn't a situation where the post commission has any significant advantage over the defense. It isn't that Mr. Martinez, the lawyer, has had these transcripts and these audio recordings and been able to go through and review them and so forth and build his case based on that, while simultaneously depriving the defense of that same material. So they're both at the same disadvantage. The transcripts are going to be a surprise to both of them. And they're both, going to have to kind of roll with that equally, depending on what the transcripts say. So this, I think, is going to cut in favor of this not being a significant problem, one that is likely going to be able to be resolved by way of, scheduling. If we're going to have to worry about when we're coming back anyway, maybe we build that into the process so that you have some more time to get caught up on this stuff that you need before you come back to continue with the hearing.
So what do you say about Mr. Devine having an opportunity to review his interview before he takes a stand in this matter?
I have absolutely no issue with that.
We all agree on that as well. So let's see. So let me ask you this: how is she going to provide that material to you?
So I spoke with her this morning and suggested a few things. I think that she's going to think them over today, and I told her that I'd call her either at lunch or at the end of the day to arrange for copying. I met with her last week at the Stoughton Police Department. I don't mind going to pick them up and make copies or whatever I need to do as well.
Which suggests, of course, just to state the obvious, that Mr. Devine and his counsel won't have this material in time for him to testify today.
Correct. I think the expectation, regardless, was that Mr. Stowe had at least a few hours of crossing Deputy Chief Holmes, and he's not expected to get here until 2 p.m. So I think that was hopeful, a hopeful thought that he would begin to testify today. But I think that's fair to say.
So putting on, although it was many years ago when I was sitting up behind those desks as a lawyer, that's when Ben Franklin and I used to be. If I were sitting in his shoes, I might be saying right now, well, wait a second, I've got Holmes on the stand who has relied on material which he said existed, and that's not inconsistent with what we're now learning, but is somewhat inconsistent is his assurances that everything was provided to post. But putting that aside, this is material he reviewed when he wrote his report, and the reports are kind of, I'm hearing just sort of a summary of what these interviews were saying, or identifying the stuff that he was most interested in and thought was important. So as I was saying, if I were in Mr. Stowe's seat, I might be saying to myself, well, how can I complete my cross without having a chance to review those transcripts and recordings as well? Is that something Mr. Stowe might say?
That's something Mr. Stowe is saying. I can't. I just went through all the witness statements with him in his report, and now we're going to get them into what they really say.
I get it. And I'm sure you don't think differently.
I would consent to that. And after the testimony yesterday morning, I would not have been surprised if after we received the transcripts that those witnesses would be recalled. And that's something that the division would not oppose either.
Yeah.
But however, if it needs to be done and we need to put off Chief Holmes's cross for another day or even continuing so that we're all on the same page, I don't think that we would object either.
So here we are once again in a mess because these police departments can't get their shit together when it comes to their documentation. You know, we saw it in Karen Reed with reports that get written, you know, a year and a half after the fact. No reports on critical things, reports that omit details. Oh, reports that, you know, put the wrong address for the Albert residence. Reports that omit things like who was present at the house. These documentation failures. Now, whether they were truly failures in the Karen Reed case or, you know, deliberate omissions is probably more of a question. But at the very least, there seems to be this pattern of a very, very sloppy practice, very, very sloppy, negligent documentation, and that's a problem. This right here, this is why this kind of thing is a problem. It's just, you know, I'm sorry that paper management is part of your job as a police officer, but it is. It is in the military too. As you get up, you know, into higher levels of administration, you want to be the boss of a police department, then you better have your shit together when it comes to keeping track of the paper. Because now they're talking about maybe we'll just have to recall everybody. Well, everybody isn't that big of a deal. It's McNamara who didn't know, you know, she wasn't part of the investigation anyway. She doesn't know anything about it, and Holmes is still mid testimony. So we're not in a terrible situation, but you know, we could have been, and you know, if nothing else, now we got Holmes gonna get confronted with the fact you said on your sworn testimony you gave this all to Post, and here it is over there in your police department. You never did. Were you as careful with your investigation of Mr. Devine as you were with your testimony about your handling of the transcripts? May or may not land, you know. If Mr. Devine is going to testify, then, you know, credibility might be relative. Might just be a relative question. But you know, it's just it's why it's so aggravating when these just very basic things. Keep track of your paperwork, handle it carefully, keep a chain of custody, know where your things are. These matter. This is why you might be blowing the case against this guy right now, because you didn't have your shit together when it came to getting the transcripts provided. That would be quite unfortunate, wouldn't it?
Makes sense.
That's me too. I don't, you know, we worked very hard. Everybody did about getting ready for this. I appreciate that. It's a part of the effort that we're making at Post to do these things in a timely manner and in the interest of both the respondent and the division. And you know, we do the best we can, but sometimes circumstances arise which change the impact of proceedings. So I can't imagine that we wouldn't give you a chance to do that. I think we should, rather than have to repeat stuff, we should get word to Chief Holmes, who will be advising him of his, when he has to come back, and reminding him of his obligations to, under the protective orders. Is that agreeable to everybody?
Yeah, yes.
Yes.
And when we get done with, do you have a problem with, now that we have at least one of these witnesses here? Is it her, right?
Her,
Putting
yes.
her on?
Haley Hogan, yes.
Are you okay with putting her on out of certain term here?
No, I'd like to preserve and take her.
Was she a recorded? No, she wasn't. No.
She has an affidavit, which is page 763.
Okay, so but there's no recording of her, of an interview of her.
No.
Okay.
I would ask that, given the witnesses here, that, well, actually, I'll defer to Mr. Stowe. However, if the witness does not return, I would also apply that on the other party as well to ensure her.
That's right. Well, let's do this. You're requesting that you don't put on any evidence until the division's case is fully presented.
Correct, and now we've got these, as we've said, we've got all these transcripts to go through. I would have expected that to be done with Deputy Chief Holmes today, but now it's, we're gonna go through a volume.
Well, I would suggest this. Well, and before you take a position on what Mr. Martinez just said, why don't I bring the witness in? Explain the witness that circumstances have require that other evidence be presented before she gets a chance to testify. Tell her that, is she literally under subpoena?
Yes,
Okay, that she's under subpoena, that she's going to be advised at a new date. She's going to be required to appear on that date, ask her if she's willing to do so. And if she resists at all, to explain the consequences of violating the subpoena.
makes sense.
Everybody right with that?
That's fine. Yes.
So why don't we go ahead and bring her in? Thank you.
May I text Chief Holmes? Chief
Yeah,
Holmes?
wait a minute then.
Yeah. But may I quickly text Chief Holmes to let him know we don't
Yeah,
need her today?
yeah.
And then can I ask for an official email from Post-C Review as well? I can forward his email address.
Okay.
Yes, that'd be great. Thank you.
So that's why it's a short hearing, because we're not
Haley Hogan,
taking any testimony today.
H-O-G-A-R.
Hogan.
H-A-R-L-E-Y.
H-A-Y.
H-A-R-L-E-Y. Hogan, H-O-G-A-N.
Haley Hogan is witness who is going to be brought back. So kind of annoying for her, right? Kind of annoying for her. She did whatever you have to do to arrange your day so that you can be here as a subpoenaed witness because you don't have any choice. And you're going to have to do it again. You're going to have to put that suit on again. She has perhaps the longest fingers I have ever seen in my life. My goodness. How much of that is acrylic nail?
Yeah. Okay. Morning.
Good morning.
All right. Would you say your name?
My name is Haley Hogan.
Okay. And I'm going to actually put you under oath now. Would you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth in connection with these proceedings? Thank you. You can have a seat.
A lot
As
of
it turns
acrylic
out, this
nail.
is going to be, at least right now, a very short appearance on your behalf, and we appreciate you responding to the subpoena appropriately and being here. We have developments in this case that's going to require that, unrelated to you, by the way, so you don't think this is all about you. But it's going to require that other evidence be presented before you testify in this matter. So we're going to have to delay the receipt of your testimony in this case. What that means is, again, I know it's disruptive to your life, and I'm sorry about that. There's nothing much I can do about it. But what it means is you'll be advised of a new day for you to come in, which is going to be maybe as long as 2 weeks away, for instance. You can be in contact with Mr. Stowe, who issued the subpoena to you, about the schedule. We'll make sure you get notice of that. And do you understand that because you're subpoenaed and because you're still under subpoena, you'd be required to appear on that new date?
Yes.
And do you have any problem with that?
No.
Okay, great. Anything else you want me to tell the witness? You may already know this, but these proceedings happen to be closed proceedings under court order or hearing officer order, and and there are also 2 protective orders that have been issued in this case, which require people who have gained knowledge or have knowledge regarding what's happening in these proceedings, not to divulge any of that to anybody else, to the public, to friends, neighbors, anybody. You've just got to keep it to yourself until sometime you're relieved of that obligation. I don't know if you've ever seen those protective orders.
I don't think so.
Are you? And we can get you a copy of those. All right, just so she's aware of those. But you understand what I'm saying?
Yes,
All right. So you really got to make sure you don't talk to anybody about it.
absolutely.
All right. You have any questions for me before I let you go?
I do actually have one question. I will be out of state in 2 weeks. Is that gonna have any effect on?
Are you out of state permanently or for a long
No,
time?
just for 4 days. So I just didn't know if it would interfere.
You know, we haven't scheduled the new
Okay,
dates, so
okay.
if you, what dates are you gonna be away? So you might as well tell us.
I leave June 20th and I return, I want to say the 24th, the 24th.
So June 20th is probably like a Wednesday or something.
I believe it's a Friday.
Friday. Oh,
Yeah, just a weekend
Oh, okay.
thing.
yeah, well, we're not working on this case in the week. Well, we may be working out. We won't be here on the weekend. Okay. Well, thank you for letting us know, and we'll certainly make sure we accommodate your schedule.
Thank you.
All right. Thank you. Have a good weekend. Thank
Thank you.
So June.
Is there a way to call off
Was subpoenaed to appear at 10 o'clock this morning. I subpoenaed them both for 10 o'clock this morning. I actually subpoenaed them for the other building. And then we got the notice of change. I sent them a letter with your instruction about the weapons policy. So they would have received that as well.
You haven't heard from them.
I haven't heard from them.
Have you made any effort to contact them?
I don't know. We don't have a number. Mr. Devine has tried.
So you have a number to call them at? And
Do you have a number?
It goes straight to voicemail right now, so I don't know what the issue is. Like I said, yes.
so, but it's good to know, because having told me that, I'm gonna ask you to contact him in writing and contact him by leaving a voicemail for him, so he knows that he was required to be here, but as things turned out, his appearance has been continued to whatever date we figure finally scheduled. Make sure you get it to him in writing as well. Remind him that the hearing officer has stated that he's still under subpoena. And again, all right. Anything else we should be thinking about then? You'll I'd be interested even if for some reason that I can't anticipate, the material you received from the Stoughton Police Department that we're talking about today doesn't get introduced into evidence in this case, because I have a parallel concern about the failure to provide that material to the division. I want to make sure that we get copies of it as well.
Yes,
But whether it's admitted or not is another question.
no problem.
One issue with scheduling, Your Honor, is that if I get this information and then it leads to me having to do some follow-up discovery or subpoenaing in witnesses that are referenced in those statements. If the statements are starkly different from what any of the information I've seen, I may want to subpoena those witnesses. And I need some lead time to do that. So first, I don't know when I'm going to get them. I presume I'm going to get them. I've been working with Attorney Martinez for a while.
My guess is you're going to get these pretty quickly.
Yes, I would like to give the chief an opportunity to collect everything so that I can make one trip. I'm in the office Monday and Wednesday of next week. I plan to go down on either one of those 2 dates, and Attorney Stowe is always pretty amenable of coming down to the office. My plan is to, if I get a hard copy of the transcripts, is to scan them and make a digital copy to make it easier for everybody. So I would very much expect by the end of next week that everybody should have the materials.
Yeah, but there's also the audio recordings, right?
Correct.
Yeah.
That's what she's currently trying to locate.
Oh, right.
Yes.
But I mean, somehow you'd have to get copies of those to.
Correct. Yes, attorney still usually comes into the post office. We've had the post commission office. The post commission office. He's been probably 8 or 9 times already. So we fairly consistently have met.
You know, it's mostly retired people who go to the post office every day. All right. That's helpful. Anything else the parties want to bring up while we're here?
I will say, in scheduling a hearing, or in scheduling the next hearing date, just given that we're not currently aware of the volume. I think it would be, I would like to check with Chief Holmes and scheduling.
Yes.
I think it would be, that maybe we could do suggested hearing dates at the end of next week.
That's fine.
Once we have an idea, and then,
Well, and I have in mind that, it actually may impact both sides, about whether you want to get a further information or further investigation. So I want to leave enough time for you to do that.
and the only thing that I could expect will be an issue with collecting the materials is if they're in Chief Holmes's possession. He's currently under cross. I don't mind having a witness present or anything to show that if we're discussing things that it's only the collection of materials, or I don't mind working with the post-commission legal department either to collect those documents if they happen to be in Chief Holmes's possession. I do just want everyone to be aware that it's a possibility that he may have copies and he's currently on the stand. I don't, in other words, I know I'm not supposed to speak to him about the case.
Oh, I see what you're saying.
Because he's currently on the stand.
He may have, even though he's no longer a part of the department, he may have copies?
Yes.
And where do you get that idea from? Where do you get that idea from? He's the chief in a different, he took them with him and you have a reason to think you might have them. Did you get a like oopsie mea culpa? Anything like that? Not saying a lot more than that. Yes. Huh.
Is there a specific reason you believe that, or just it's a possibility?
So Chief McNamara suggested to me that Chief Holmes was the one who was in charge of the investigation and he will know where the materials are. I'm not necessarily suggesting that he is in physical possession of them, but he may be the person who knows where they are. And he will have to coordinate with either me or Chief McNamara for those materials.
Are you, whether he has them or he will have access to them as a result of helping to collect them, do you have a position on whether either one of you have a position on whether he should be able to review any of that material before he gets back to the witness?
Stowe's going to say
In
no.
his testimony where he gave representations to support that Mr. Devine had said he never had any contact with SB. And in fact, the report said something different. I want his memory to be as it is, not refreshed by documents that nobody's seen on either side of the table. So I'd like his memory to be to just be his memory versus him refreshing it this time. And we need to refresh it with the documents. That's fine. That's what we do. But for him to prepare with documents that we haven't seen, I think is prejudicial to us.
The counter argument to that is that if he can refresh anyway, then what's your problem? You want him to come in unprepared. I mean, I know you want him to come in unprepared because you want to try to be able to catch him and stuff. And he seems to be, potentially one of these people that rather than just say, I don't know or I don't remember, will fill in the gap. And then may not always be right about that. May not always be right. So of course that's what you want, but it's not improper for him to refresh his recollection, review the stuff to complete his testimony. It's just that if he hasn't already done that, he doesn't seem real interested in doing it. I don't really suspect he probably would. I don't know though.
I think that that's a fair notion. However, my recollection of the testimony is that he was reading off the page and said, clearly he had no social contact. Just want to make that one distinction. But other than that, I do not. Yes.
My only question is, you have a problem with instructing him not to review this material at this point in time?
I do not, and I'm more than happy to do so.
All right, if you tell us the order of the hearing officer as well, okay?
Yes.
Thank you.
That So I have not subpoenaed the Stoughton Police Department for the documents, but I did let Chief McNamara know if by the middle of next week we have not received them, that I would be serving a subpoena. I don't mind issuing that as a party. However, if I know that you're going to be away, but if for whatever reason it needs to be signed off on, or you believe it needs to be signed off on by you, I can also provide a copy for your signature as well.
Yeah. And I'm not out of touch.
Yes.
So,
Okay.
You should be out
I'm
of touch.
thinking about that now, about whether under the unusual circumstances that we find ourselves
And on
in,
vacation to Europe.
whether even if they're willing to voluntarily find and produce this material, that it should be under subpoena anyway. Just so there's never, just so they understand their obligation. It's not it's more than a request. Are you right with Devine issuing and having a subpoena done?
I think that's
So why don't you arrange for that? Well, that proceed.
It does make a cleaner record to do it under subpoena.
just as of now, just so we don't have to go back and forth, are the three things the written transcripts, the audio transcripts, and the interview warning documents that we're looking for?
Yes, that's, I believe, that's what you testified. Yeah, and we're on it. This is more that we have got.
So the only other thing that occurred to me, but I think that there were one or two witnesses where rather than a recorded interview, they said there was summaries. He said, see summary below. It turned out that there wasn't one, but then when you went down further, we found
One.
the summary. Were there any others that were similarly stated where they said there's a summary, but there was none?
So I think the three, I had jotted them down to do redirect. I think the three that had mentioned came back up later when sort of we scrolled down the document.
All three.
Yes, I don't think that, I crossed them off. I don't think that we needed to clean that up any further.
All right, but in answer to your question, if you folks look at this and say, wait a second, Mr. X's summary wasn't there, even though it said it was in the thing, make sure you include that in the materials that they need to look for and produce.
Okay.
All right. It may be unnecessary, as you suggest.
Okay. That sounds good.
Anything else? All right, well, we'll be in touch and certainly about scheduling. I don't need to tell you that we're still bound by the protective orders, and the order of closure here. We have a curious media, which is their job, so but we can't talk substantively about this. All right, we'll be in recess.
Well, that was incredibly boring, wasn't it? How uneventful. Nothing but issues about transcripts. Well, I didn't realize, I guess, the time frame in which this was taking place. So this hearing clearly took place many months ago. They were talking about rescheduling, and she's saying in 2 weeks I'm not going to be available, and that's June. So this could have been as far back as sometime in May of this year. I did a little bit of looking into kind of what the process is for these types of hearings, and it's a little bit confusing. What appears to be the process is that when a recommendation, somebody requests that an officer be decertified, it's referred to the post division, and the post division does an investigation and makes a recommendation based on that. But the recommendation isn't binding. The recommendation goes to the full post commission. And the full post commission has, I think, some authority to decide like different ways that they want to handle it. But one of the options is to refer it to a hearing officer for a full hearing on the recommendation, basically. And so that's my understanding of the posture of where we're at with this. So assuming, this hearing was done, of course, I don't know yet when they came back, but it at least started back in May. If this proceeding has been done for a while, we might just be waiting for the hearing officer's decision at this point. I have checked the post commission website. They do keep pretty good accessible public records, consistent with what this gentleman has talked about as far as his concerns for transparency. It's very easy to search, get copies of findings and reports and stuff like that. So, for example, you can go into the Massachusetts Post Commission records and find the voluntary decertification agreements of Matthew Farwell and of his brother William Farwell. There is also, I believe there might have been a similar one for Josh Heel. There's some kind of order. See if I can bring it up. Yeah, in fact, I'll just go ahead and share it with you guys so you can see what it is that I'm looking at here. Let's make it bigger than that. So this is the kind of thing you can get just like right off the website. It's really convenient. So Joshua Heel, he was the animal control officer that was involved. He allegedly gave Sandra BIRCHMORE a cat in exchange for certain favors. So here's what they agreed. They entered into a disposition agreement. He shall never again apply for certification as a law enforcement officer within the Commonwealth of Massachusetts. He shall never seek or hold employment by any law enforcement agency, sheriff, or the Executive Office of Public Safety, nor any entity thereunder. He shall not appeal, seek to reinstate his certification, or otherwise challenge his current certification status of expired. And the executive director is going to publish this agreement on the website. So what does this mean? It means they didn't decertify him. They agreed to just let him stay expired, but he can't try to be a law enforcement officer in Massachusetts again. He may, however, be able to go try to be a law enforcement officer in some other state. So this is a fairly recent decision, just as of last month. So here they have this agreement. They'll have some of these factual findings. I looked at these for the Farwells, and what it does is it lays out what the accusations against them were. But typically it is like, as you can see here, the respondent denies each and every allegation of misconduct. They agree to, what they essentially agree to is that if these allegations were proven, it would be sufficient to justify, decertifying them, but they are not admitting any fault. They're just agreeing to voluntarily accept the penalty. So he resigned from the Abington Police Department while disciplinary proceedings against him were pending. They sustained multiple allegations of misconduct against him, found to have engaged in conduct unbecoming an officer, to have been untruthful during multiple interviews as a witness, in connection with a separate investigation of other officers employed by a different law enforcement agency, and to APD's chief of police in a meeting regarding those interviews. So he's the one who was the witness. He was, not necessarily a target of the federal investigation, but they found out about him, and so he was questioned. Vis-a-vis the investigation of Devine and Matt Farwell and William Farwell, and apparently was found to have been untruthful. The conduct unbecoming, I think, has to do with what I said before. So he denies all that, but it's expired. Public interest is best served by disposition without further enforcement. So he agrees that if, this is the same language, if they were proven by clear and convincing evidence, which is the standard, it's also going to apply to Robert Devine's case, it would permit the commission to impose significant discipline up to and including decertification. he agrees, you know, all of the things that that were set out there. If he fails to abide, if he breaches this agreement, violates it, goes in and applies, for example, tries to become a law enforcement officer in Massachusetts again, they can impose discipline against him. Waives a right to contest the factual findings, and agrees that these are going to be public documents. So anyway, that's the kind of thing that you can see available on post. And we don't have a final order yet for Robert Devine. So whatever our time frame is here, as far as I know, I mean, maybe there was like a really lengthy delay before they got back, and they only finished these hearings, you know, fairly recently. But we don't have a decision yet. So one of the questions that I know is going to come up is, so what is that final? He can appeal it to Superior Court. He can appeal it to Superior Court. He's going to have a right to do that. That's pretty typical with administrative appeals. You have the ability to take it into the court system for a review, and they're going to be looking at, you know, did they apply the right standard of review, the clear and convincing evidence? Did they make the correct legal rulings as far as the admissibility of evidence and so forth? And so in many respects, those are going to be, you know, the same kinds of standards that you expect to see in any type of court proceeding. Oh, another question that came up that I also took a chance to dig into a little bit. I saw in the comments folks wondering, hey, so Farwell's been decertified. William Farwell's been decertified. They didn't retire. This guy, though, he retired, right? He retired before they could complete the IA investigation. So does that mean he still gets a pension? Yeah, guys, it does. It does. This guy is still getting paid by the Massachusetts taxpayer for, you know, his 20 years of service, or however much ultimately it ended up being that he put in. To forfeit your pension in Massachusetts requires some kind of commission of a criminal offense. There's like a limited exception for accusations that involve like disciplinary proceedings that involve accusations of misappropriation of funds. That's not at issue here. So no, guys, he gets to keep his pension unless you're convicted of a crime relating to your law enforcement duty. You get to keep your pension, even if you are a terrible cop. You're such a bad cop that they take away your certification, your ability to continue being a cop, and that's a factor of civil service protections. That's a factor of collective bargaining. And what they're entitled to. It's quite a generous system to police officers over there in Massachusetts. And so you can see kind of how some of the incentives are at play here. Why he is kind of getting this have it both ways type of situation where he both gets to keep his pension, gets to cash in, doesn't you know, run the risk of losing that, but also, you know, getting to demand this hearing to clear his name. Well, we didn't really make any progress one way or another on clearing his name today, other than just opening right up with the hearing officer noticing, hey, article in the Globe seems to suggest, Mr. Devine, you're a lying liar who lies. Do you have any comment about that? Telling the Globe that he wanted a public hearing while the attorney is filing documents indicating that it should be closed. So intriguing that was noted. But he's not the only one now with the credibility issues, because the transcripts, they found the transcripts. And they're looking for the audio recordings, and you know, Holmes insisted up and down, I gave all that stuff to post, but it appears he didn't. And McNamara is still saying he's the one who knows where it is. So that's going to come up when he gets back on cross, whenever cross-examination turns out to be. So yeah, short one today. Not really anything super substantive. Oh yeah, we got that one other detail, the new exhibit that was brought in, the bar admission date of Robert Kuhn, the other police officer who went to law school that Mr. Devine is trying to point the finger at to imply that he's the one in the text messages with Rob. He's the one, because part of the context of those text messages they've made clear has to do with being in law school and or being admitted to the bar. And he was not admitted to the bar, Mr. Kuhn, until November of 2022, which is, almost 2 years after Sandra BIRCHMORE's death. She died in February 2021. So timing isn't going to work for that little finger pointing. And if it's not going to work for that little finger pointing, then it's going to undermine his credibility pretty significantly to be pointing the finger at him. But yeah, the people that always have an excuse, they will always have an excuse. It doesn't matter if it's like not factually possible. that's just something you shouldn't worry yourself about. If he says it's Robert Kuhn, then it's Robert Kuhn. And how dare we rely on objective reality to question whether that is in fact the case. So guys, yeah, short one, but still more to get through. So with that, have a wonderful evening, and I'll see you guys back for part 4.